We will hear argument this morning in Case 25-332, Trump versus Slaughter. General Sauer.
Mr. Chief Justice, and may it please the Court. In SELA law, this Court held that the President's power to remove and thus supervise those who wield executive power on his behalf follows from the text of Article 2, was settled by the first Congress, and has been confirmed by precedent, including at least 9 decisions of this Court from Ex parte Hennon through Trump against United States. Humphrey's executor stands as an indefensible outlier from that line of authority. It's holding that federal agencies can exercise quasi-legislative and quasi-judicial powers that form no part of the executive power has not withstood the test of time. That holding was gutted and refurbished in Morrison, but this Court correctly rejected the refurbished version as providing an amorphous test with no limiting principle. Respondent now proposes a third update to Humphreys, which this Court has already rejected as making no logical or constitutional sense. Humphreys must be overruled. It has become a decaying husk with bold and particularly dangerous pretensions. It was grievously wrong when decided, and cases from Morrison to Trump have thoroughly eroded its foundations. The Court has repudiated Humphrey's reasoning and confined it to its facts, but it continues to generate confusion in the lower courts, and it continues to tempt Congress to erect, at the heart of our government, a headless fourth branch, insulated from political accountability and democratic control. As Justice Thomas wrote in SELA law, Humphreys poses a direct threat to our constitutional structure and, as a result, the liberty of the American people. And as SELA law held, the modern expansion of the federal bureaucracy sharpens the court's duty to ensure that the executive branch is overseen by a president accountable to the people. I welcome the court's questions.
General Sauer, could you give us one example of a permissible restriction on the authority to remove a principal officer?
We don't believe there are permissible restrictions on principal officers of the United States who exercise the executive power. Now, there may be separate issues relating to particular historical pedigrees.
In this case, in a multi-body agency such as the FTC, is there any permissible restriction?
No, this court in Trump against the United States held that the president's power to remove officers wielding the executive power is conclusive and preclusive.
How far do you go with that? Can it be arbitrary, completely arbitrary?
It is conclusive and preclusive, so any review of arguably bad reasons for the president to remove an executive officer would be subject to the political process. It would not be subject to judicial review, and certainly not subject to statutes regulating that.